Hello and welcome to Courts Today by LiveLaw. Let's get to today's top legal updates. Communist Party of India files writ petition in Supreme Court challenging Waqf Amendment Act 2025. President ought to seek Supreme Court's opinion when Governor reserves bill on ground of unconstitutionality. Supreme Court. Kerala becomes first in India to launch Online Permanent Lok Adalat services. Risk factor higher than loss which may be caused. Calcutta High Court declines to stay FSSAI order against sale of prohibited batch of Dabur Honey. With time, a bond may develop. Andhra Pradesh High Court grants visitation rights to father whose son was witness against him in mother's murder case. I'm your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end and don't forget to like, share and subscribe to our channel because your support means the world to us. Before I get to the details, here's an exciting opportunity for judiciary aspirants. LiveLaw Academy, LiveLaw's Judiciary Coaching Initiative, has opened registrations for its May batch. Choose from two tailored courses, JSEP 2.0, a comprehensive 18-month online program covering everything you need to crack the judiciary exam, taught by an expert panel including retired judges. JSEP Lite, a flexible weekday-only program for those who prefer a structured yet lighter approach. Sign up today as the 30% discount for the early birds has been extended. Enjoy free LiveLaw subscriptions, case compilations and much more. Don't miss this opportunity. Enroll today at www.livelawacademy.in. In another update on the Waqf Amendment Act 2025, the Communist Party of India has approached the Supreme Court with a bold challenge against the newly passed law. Filed by CPI General Secretary D. Raja on April 9th, the petition claims that the amendments violate the fundamental rights of nearly 50 lakh Muslims in Tamil Nadu and 20 crore Muslims across India. Represented by Advocate Ram Sankar, CPI's move follows a resolution passed in the Tamil Nadu Legislative Assembly led by Chief Minister M.K. Stalin, urging the centre to withdraw the bill. The Supreme Court will now hear a total of 10 petitions challenging the Waqf Amendment Act on April 16th before a bench headed by Chief Justice Sanjeev Khanna. In a major takeaway from the Supreme Court's judgment in the Tamil Nadu governor case, the court observed that when a governor reserves a bill for the president's assent on the ground of unconstitutionality, the president should prudently seek the Supreme Court's opinion under Article 143. Article 143 empowers the President to seek advisory opinions on important legal questions. The court emphasized that the constitutional courts alone have the authority to interpret laws and adjudicate on constitutionality. Both the Sarkaria and Panchi commissions had recommended such references. Since governors can't seek judicial advice directly, referring bill to the President, who can then consult the court, is the only viable route. This practice can prevent unconstitutional laws, conserve public resources, and avoid bias. The Union Executive should not assess a bill's wires. It must defer to the Supreme Court's opinion, which holds persuasive value. If the President deviates from it, clear reasons must be provided. Kerala has taken a historic step that sets a benchmark for the rest of the country. It has become the first state in India to introduce online filing and hearing for permanent Lok Adalat cases. This major initiative by the Kerala State Legal Services Authority or KELSA is a game changer, especially for people in remote areas who earlier had to travel long distances for even small claims. Now, litigants can file cases from anywhere in the state, saving time, money, and effort. Operational from the first week of May, this service will allow online hearings, and this can make sure that it's available for everyone in the state. To ensure equal access to this facility, help will be provided through e-Seva Kendras and legal service authorities at the district and taluk levels. The Calcutta High Court, led by Justice Om Narayan Rai, refused interim relief to Dabur India Limited in its writ petition challenging an FSSAI prohibition order on a specific batch of Dabur Honey, batch number NP5819, manufactured on 13th February 2024. FSSAI's counsel, senior advocate Vinita Meharia, argued that Dabur's statutory appeal filed on 19 September 2024 wasn't admitted due to missing documents and fees. Dabur's counsel, Mr. Surajit Dasgupta, refuted this, citing annexed documents and claiming violation of natural justice. He also challenged the recall order's validity, arguing that it wasn't communicated to Dabur and relied on a Jammu and Kashmir High Court judgment. The court noted the prohibition was interim and limited to one batch, not a total business halt, and based on risk to public health. It declined to stay the order, citing potential harm outweighing Dabur's loss. The court directed FSSAI to file an affidavit on appeal communication and granted Dabur liberty to revive its relief request post-filing. The Andhra Pradesh High Court granted conditional visitation rights to a father acquitted for murdering his wife, despite his minor son being a witness against him. The child remains in the custody of maternal relatives who filed the case. Though the father sought custody under the Guardian and Wards Act, the court denied it, citing concerns about the child's safety and mental state, noting photos showing possible strangulation marks and the child's consistent unwillingness to meet the father. While acknowledging the father's acquittal and efforts through legal channels, the court emphasized the child's welfare and upheld the trial court's decision denying custody. However, to prevent the father-son bond, it granted limited visitation rights, citing the Supreme Court's stance in Yashita Sahu versus State of Rajasthan on a child's right to both parents' affection. The court emphasized cautious interaction, hoping that misunderstandings may resolve over time, and dismissed the custody appeal.